Joshua D. Koskoff, one of the lawyers representing relatives of victims in the massacre at Sandy Hook Elementary School, outside the Connecticut Supreme Court on Tuesday. Jessica Hill for the New York Times. Hartford. The Connecticut Supreme Court heard an appeal on Tuesday brought by relatives of victims in the massacre at Sandy Hook Elementary School who argued that the companies that manufactured and sold the military-style assault rifle used by the gunman should be held responsible for the 2012 attack. A lawsuit filed by the relatives said that the AR-15 style Bushmaster used to carry out the shooting in Newtown, Conn, that killed 26 people, including 21st graders, was specifically marketed as a weapon of war, with slogans and product placement in video games invoking the violence of combat. The lawsuit claims that such promotions were a deliberate effort to make the weapon attractive to young men, like Adam Lanza, the 20-year-old gunman. Remington may never have known Adam Lanza, but they have been courting him for years. Joshua D. Koskoff, one of the lawyers representing the families, told the panel of judges, referring to the gunmaker that was named in the suit, along with a wholesaler and a local retailer. The courtship between Remington and Adam Lanza is at the heart of the case. The lawsuit, brought by family members of 9 people who were killed and a teacher who was shot and survived, was elevated to the state Supreme Court after years of working its way through the court system. The case started in state court, where it was first filed in 2014, and then it moved to federal district court before returning to the state level, where a judge dismissed the suit last year. The families appealed to the Supreme Court to reverse the judge's decision and allow a jury trial. The families have infinite patience to see justice done and utmost faith in the legal system to serve the people it is meant to protect. Ian Hockley, whose 6-year-old son, Dylan, was killed, said outside the Supreme Court on Tuesday, "We have not lost 1 ounce of confidence. The case represents an ambitious effort by the families and relies on a novel strategy to find a route around sweeping protections provided by federal law to shield gun companies from litigation when their weapons are used in a crime." Supporters contend that if the case is brought before a jury, a trial could offer a glimpse into how the gun industry operates, and it could also offer a roadmap for the survivors and relatives of victims in other mass shootings as they pursue legal action. A lawsuit claims that the AR-15 style Bushmaster that was used in the shooting in Newtown, Conn, was specifically marketed as a weapon of war. Jessica Hill for the New York Times. Despite significant hurdles that stand in the way of its success, the case has nonetheless fueled an intense response from both sides of the gun debate, who see it as a potential threat to the company's legal protections. The gun company's lawyers have argued that their clients were immune from the claims cited in the lawsuit, and they cautioned that agreeing with the family's arguments would require amending the law or ignoring how it had been applied in the past. "The shooting was a tragedy that cannot be forgotten," James B. Votes, a lawyer for Remington, told the judges. "But no matter how tragic, no matter how much we wish those children and their teachers were not lost and those damages not suffered, the law needs to be applied dispassionately." In 2005, Congress passed the Protection of Lawful Commerce in Arms Act, which blocks lawsuits by providing industry-wide immunity from blame when a gun company's product is used in a crime. Backers of the measure argued that it was an essential protection from predatory or politically driven lawsuits. The law includes exceptions for sale and marketing practices that violate state or federal laws and instances of so-called negligent entrustment, in which a gun is carelessly given or sold to a person posing a high risk of misusing it. Negligent entrustment has previously been used to sue gun sellers, but the Sandy Hook lawsuit seeks to broaden the scope to include a gun's manufacturer. It argues that the companies erred by entrusting an untrained civilian public with a weapon designed for maximizing fatalities on the battlefield, and that its advertising, relying on messages of combat dominance and hypermasculinity, "Consider Your Man" card reissued, specifically appealed to disturbed young men who could be inclined to use the weapon to commit violence. From left, Mark Barden, Nicole Hockley and Jill Russo, all of whom had children who were killed in the massacre in 2012, appeared outside the Supreme Court building. Jessica Hill for the New York Times. But the gun companies argued that the family's lawsuit was exactly the kind of claim that gun companies were shielded from. The state court judge reached much the same conclusion when she dismissed the suit. If the federal law doesn't apply in this case, asked Christopher Renzulli, a lawyer representing Camp 4, the wholesaler, well, then what case does it apply to? Justices asked about the weapon's firepower and its use outside of combat during the roughly 90 minutes of oral arguments on Tuesday, which came a month before the shooting's 5th anniversary and is set against the backdrop of the recent deadly mass violence in Sutherland Springs, Texas, and Las Vegas. Justice Richard N. Palmer referred to the family's view of the weapon, saying it is really a killing machine from their perspective. The weapon used by Mr. Lanza was capable of carrying 30 rounds. What is a 30-round magazine used for? Justice Palmer asked. You want to be able to fire your gun repeatedly without reloading, Mr. Votes replied. It's as simple as convenience in target shooting. Justice Andrew J. MacDonald noted various slogans used for marketing, such as forces of opposition bow down. I mean, if it's used for hunting a target practice, he asked. What's the purpose of that ad? Well, it's also used in defense, Mr. Votes said. In a home defense situation, if I felt the need in a firefight to defend myself and my family, I would certainly want to choose whatever firearm would force any opposition to bow down. Follow Rick Rojas on Twitter @Ra.